Welcome back, everyone, to the Lawcast. I am Chris Santana, and this is Melanie Thorley. We're both solicitors here at MJT Law, and we're here for our second episode of 2022. So today, I've got a couple things that I want to talk about, especially a wild case about when I think personal relationships or overly familiar workforces become an issue.
Oh my
Um,
God, this happens all the time.
Yeah, well, we have a workforce which is largely found in small and medium enterprises, and people get close, and they can sometimes become almost family, but it intersects with employment big time, and it's sort of what happens after when things go a little bit wrong. Um, I'm going to kick it off with
Go on.
so it's the case of Blake O'Keefe and the trustee for Dunshee Family Trust, and I'm going to put this as a colloquially the case of Cracker the Galah
Okay.
because the case was released a couple of weeks ago, and it involves um, a particularly young employee who's basically worked for a sort of mum and dad company who operate a business on their private property. He's sort of worked on a casual basis while he was like studying and in high school, and then had just finished his kind of uni and started work on a more full-time basis, still on the property. Now, on the property is I think it's fairly regional. So there is, cats, dogs, birds, family pets around.
Mm, okay.
And and unfortunately, on a particularly you know, unfortunate incident happens late last year where this young chap is reversing a truck, and there's CCTV in this particular property, and he looked to the sides, he looked to the in his rear view mirror and looked on his mirrors, and he reversed the truck, parked it up, and shortly after, the employer kind of comes out and says, "Where's Cracker? Where's Cracker the Galah?" Uh,
A family pet,
a
Cracker.
family pet is his name.
Okay. Okay.
And he's kind of looking all over the shop. Where is it? And it quickly becomes clear. And apologies for the mental image that the truck had been reversed over Cracker the Galah, and it was no longer alive. Um, and the employer cracks it, saying things like, "You've turned into someone I despise. You're the worst kind of person, a person who doesn't think about how their actions will affect other people." He then immediately terminated him for negligence, grabbed his keys off him, and told him to never come back again. Now, this he must have really loved this bird, um, first of all. But what do
People
you
get
think?
very attached to their pets.
What do you think? I mean, this is a unfair dismissal application. What do you think? Because we at MJT we have four office pets around the
We
office, and
do.
a lot of our clients do. A lot of officers do. Have a little puppy running around. What happens when that all becomes a bit of a problem?
Goes astray. Well, there's a lot of talking about puppies. Puppies are very small and their bones are still very brittle or soft. And they're very small and they get everywhere. Puppies are
Yeah.
mischievous little creatures. They're very similar to my cats when they were kittens. And there are a lot of instances where people have stepped on dogs' legs and crushed them and
Yep.
stuff like that. How would I? How would it be if an employee damaged? Well, yeah, okay. There's a level of heightened emotion, no doubt about it. But to say someone did it, to behave as if someone did it on purpose. I mean, I think you'd have to look at. I mean, I'm sure this guy. How long had he been employed there?
7 years. Like,
7 years.
you got to think if he was kind of working, then this I'm reading between the lines here. He's been working for 7 years. He's fairly young. He was working there when he was in high school. He's either a family friend or at least has become fairly close with the
What
family.
what region Are we talking about a regional place? I mean, this sounds to me as if it's this guy knew that all the pets existed, probably also liked them. Was there any evidence that he hated the pets? I mean,
no, there's none of that. In fact, there is some details about he was quite desperate to try and revive the bird. And apparently, I mean, we haven't seen the footage ourselves, but they talk about it in the case that it's all on footage, the whole incident.
You can see him running over this pet.
The whole thing. And
yeah, okay. Look, I don't think you should dismiss an employee off the bat for something like that. That just sounds excessive. Yes, it's very, very sad. Yes, it's a horrible accident. But quite frankly, people don't go to jail when they run over their own children.
No. And I mean, if we break it down, like, pets are an interesting thing. Animals are an interesting thing in law, that they are treated exactly like property. And think about if he reversed into, it could be anything,
table or something.
A table or something valuable. Let's something fairly valuable. Well, what do we look for here? We're looking for negligence, really.
Yeah, you are. You're looking for purpose. You're looking for, whether the person was reasonable. And look, it's without all the proper cameras, and even then you can't be certain. I doubt you could ever be certain that there's gonna be a. Wow, that's really unfortunate. So he was terminated on the spot.
Terminated on the spot, and I think it's a cautionary tale in more ways than one. I think firstly, making sure to keep emotions out of decision-making processes, because one of the problems they found in this case was the CCTV was almost unequivocal that he did all the regular checks you could expect of someone.
Yeah.
He did everything he could have. It couldn't possibly have been negligent. And he would have known, if you had sort of stopped and thought about it and looked at the footage himself, instead of kind of just being very emotional and jumping to a decision, he probably would have come to a different decision, which would have ultimately not led to the termination and the proceedings thereafter.
Do you think it was the knee-jerk interaction that caused the problem here?
I think it was two things. I think it was the emotional nature of the loss, as well as the knee-jerk, almost the kind of associated knee-jerk reaction.
Poor crackers.
Poor cracker. I mean, to be fair to the commissioner, they do put a line here that, while I have sympathy for the Mr. Dunshee and his family, obviously cared deeply for this bird. The applicant's conduct was not malicious or deliberate, and it did not constitute a valid reason for his dismissal. At the highest of his actions for a young applicant may have warranted a written warning, but nothing more.
I love this case. This reminds me of a crazy case about pelicans.
Yeah, go on.
Yeah, so I can't remember. It must have been a couple of years ago, maybe 3 or 4 years ago now. I am getting a bit older. There was this bait shop near a river or an open mouth where people would go and buy bait. Yep. One of the draw cards of this bait shop was feeding the pelicans.
Yeah, so kind of grab some bait and, maybe give them a couple, sardines or something, or pilchards or something.
And this guy had been, and it's a mum and dad shop. So there's this one guy who runs it, and there's this one guy who feeds the pelicans. He comes in a couple times a day, feeds the pelicans, draws the tourists, draws people to the shop. Super, super fun. So they've known each other for like 20 years. They've been doing this for ever.
Yeah.
And one day they get into an argument, but it goes, and it's a very similar situation. I don't think in a employment arrangement, you should get so emotionally involved with your employees and your boss. I do think that there is something inherently dangerous about inviting people over to your house for barbecues, coming to weddings, all this kind of familiarity that happens in these small in these small.
Yeah, you're removing the objectivity of the whole matter.
You really are. And, and some days you might have to fire them. Some days you might have to discipline. Some days you might like your boss. And this was one of those days. They had an argument. And it wasn't just I'm kind of sick of you argument. This was a full-blown shouting, punching match argument.
In the front of everyone?
Front of everyone. Full on. Swearing. Things were flown. It was a full-on familial argument.
Yep.
And of course, he gets fired. He filed an unfair dismissal, and he was unfairly dismissed. The whole thing was a heat of the moment. If they'd stopped the thing, it was over something really dumb as well. I can't remember exactly what it was over, but it was over something really not as emotive, perhaps, as poor old Crackers.
Yes.
But certainly, another thing that could have, with a bit of objectivity, could have been staved off.
Yeah.
And he was seeking reinstatement.
Really? And how did that go? Because, in this case, by the way, so just for everyone's benefit to kind of close its eye, the applicant wins, as you can probably imagine, but they haven't turned their mind to remedies, but the commissioner did say that reinstatement's off the cards.
Reinstatements off the cards, too familiar. And this is actually, and I'm going to digress for slightly a moment from the Pelican story and Crackers. When we think of unfair dismissal, we've got two remedies. We've got reinstatement and we've got compensation. But reinstatement's super rare. Rare. And
despite being the primary remedy.
The first thing to think about is, can they be reinstated? Is reinstatement something that they want? Reinstatement's not often on the cards. Both parties don't want it. But when there is a party that wants it, it's still really rare. And I think it's about the relationship here. How broken is it?
Yeah, well, unfortunately, the proceedings themselves probably don't help.
No.
Because at that point, despite, you can't just turn the clock back around. And there are very few situations where either the dismissal or the associated proceedings don't create essentially a breakdown in relationship. Because obviously the commission, and this is just a general legal maxim, that, we're not there to put people in a position where they're going to end up back in court in the next 6 months, because that's what's going to happen. How if you were to reinstate this poor chap, after being said that he was the worst person, the worst type of person, and I despise you, they're not gonna last very long, are they? They're not gonna last very long.
Coming back from that, look, I can see reinstatement being a real option in an environment where, and this is one I always talk about my clients. If you work in a bank, work for Westpac, for instance, and I'm not poking at Westpac here, I'm just using Westpac as an example. Westpac has a pile of branches floating all over the place. They've got bricks and mortar, and you've got somebody who works in one of those branches. You can easily take them out of that branch and put them into a different branch with a different manager, different regional manager. You can have a completely different set of employees. Same with Woolworths. There's a whole pile of organisations where you can think of that. If you can reinstate, you can see how that might work. The reinstatement itself is incredibly difficult. You've got, normally these unfair dismissals are a year and a half down the track. They want, there's a question of continuity of employment. Do you kick the person out that's in that job right now, fire them somehow to reinstate this person who used to have this job? It's an incredibly complex question.
I only really seeing it ever being applicable for extremely large organizations, maybe the top 10 employers in Australia, the Telstras, the banks, the insurance companies, things like that. Labour hire companies, and specifically labour hire companies where the conduct relates to actions while they were with a host employer. So, you know, Greg has a bust up with Barry, who is, the head, the third party company, and that's fine. It turns out that he was at no fault, and his actual employer, the Labour Hire Company, actually has no issues with what happened. I can see it working for that, especially where the Labour Hire Company is large enough to essentially redeploy them into completely separate,
Yeah,
enterprise.
you can see, but in my reading, and I haven't seen one for a while, reinstatement is incredibly rare. So
It's it's really rare, and it's especially rare to ever see it agreed upon. If we're thinking about settlements,
yeah.
I've been told
I've never
that
seen
out of
one. I've never seen
thousands, there
reconciliation.
might be 5.
Yeah, I've never seen one in a conciliation either. Oh yes, I fired you 4 weeks ago. Sure, come back. I made a big mistake. I just don't see that as a reality, and I've never seen reinstatement in a conciliation. But if there's anybody out there who has experienced a conciliation, so we're talking about unfair dismissal, file on Form F2 in time, so there's no issue about that. We're at conciliation, and the reinstatement is on the table, and they've agreed that they're going to settle the matter by reinstating this person.
Yeah.
I would love to hear someone who's experienced that actually.
Yeah, and tell us why
Tell us
and what, because it
Yeah.
has to be something extremely specific and different to anything we really ever touch. Because I don't think I've ever seen. Not only do I not think I'll ever see it in my entire career, but I don't think I'll even see a situation where that would even make sense or be plausible. I mean, maybe it happens more often than we think, where it happens outside of a conciliation. And what I'm thinking about here is, think about a company, let's say 5 employees, but all of them are family members. There's a big bust up, and someone gets fired and they file an unfair dismissal. And then outside of the entire court process, there's family feuding and discussions and basically informal negotiations, and they bring the person back, and that person discontinues the matter, just kind of, and no one knows about it. I can see that potentially happening.
Yeah, maybe. I would love to hear from a conciliator out there who has experienced that. Something to say that it's happened, because my gut feeling is it doesn't. Anyway, so back to Pelican.
Yes. Tell us how it all plays out.
Pelican. So this chap, they have this massive fight. He gets fired on the spot. He's been working there like 20 years. And he has an unfair dismissal application that goes all the way through. And the commissioner essentially says, yeah, you both behaved pretty badly, but I don't see this conduct as a terminatable offence. So it's an unfair dismissal. So even though the conduct during this fight
was abhorrent,
appalling, it's a bit, I guess it's a bit like having children where you can't really see the wood for the trees. They're both at fault. And he orders reinstatements.
Yeah, get each other back together.
He wants his job back after this huge fight. He wants to be feeding pelicans again.
I wonder what happened. It'd be nice to know what happened after.
Well, I guess if we look it up, we could probably pop out there and see if the guy's still working there. I mean,
how did you manage to fix it all?
This happened, guys. How did you fix this relationship? Well, apparently the relationship was such that they really didn't, interact an awful lot either. The guy was in the shop. This guy was feeding pelicans. They were out there doing their thing.
Not going to be side-eyeing each other from across the shop, are they?
Yeah, but I do like this concept of crackers, poor old crackers, being the centre of a unfair dismissal, just like I like the idea of these pelicans.
I mean, I quite like the case because the commissioner took, let's be honest, there's not a lot of law involved in this particular case, and I think it was appropriate to do so, because if I was to give, employers one piece of advice, which is common sense actually goes a long way.
Yeah.
A lot of the principles which are contained both at common law and within the Fair Work Act, common sense actually is fairly backed up by what the regimes are. I mean, common sense, forgetting everything we know about employment law, would have said that he didn't do the right thing in his process, in his
And
decision-making process.
and I think this actually feeds into how people's employment should operate as well. Decisions should be made. This kind of stop-go moment. And we do this, we train our employer clients all the time about how when is a stop-go moment here? What are we talking about? What is it that you're unhappy about? And, what is it that you want to achieve by this? And just stop and think about what is actually going on here. Because we do get, we did the busting the myths last week.
Yep.
And there are loads of them. And we only hit the tip of the iceberg when it came to employment myths. And some of the ones I really like in terms of employment myths is that, you can't fire an employee on sick leave. You can't, all these kind of these things that people think can't happen. But if you ever stop to think, why not? Then maybe you can pick apart and pull that thread and take a bit of sensibility into it and go, what's happening here that means I can't terminate them on the sick leave. So look, I think it taking a bit of reasonability into it. Now I'm going to change tack slightly.
Yeah, go for it.
Hang on a sec. I'm just going to stop my dog from making a hole in my backyard. Hang on. Oh, so clever. Sorry,
Oh, mate.
As everyone knows, I've got these puppies, and one of them is taken to forgetting he's got a sandpit to dig in, and
digging instead,
digging
the lawn.
Yeah, not a great deal, but I can see it's the beginning of something. Anyway, I'm going to change tack. We over the period of time we've been doing the Lawcast, we've been talking about contract relationships, and we've been talking about casual employees and when they are casual. And something came up recently where we had to explore the option of when a contractor is a contractor. And you and I were talking about how, and for those who are watching, we know that we've got this kind of, we know we have a definition of a casual employee now, or a better definition of a casual employee. And we know it's about, for those who haven't been watching the Lawcast, a casual employee is essentially an employee that is determined to be a casual employee at the beginning of the relationship.
Yeah.
And it needs to be, there are some keys here, and one of them, is it needs to be reduced to writing and things like this, and it needs to be very, very formalized. And this week, a decision came up about contractors, and whether contractors are contractors or their employees, and how that relationship gets created. And I think this feeds into this whole casual employment argument, and how the High Court made this determination. Now, I actually don't like it, because, well, I don't like it. I mean, yes, lawyers love a contract. We absolutely do, and we like putting everything into writing because we like to understand the contract, the relationship between the two parties. But I also think that employment is and the court agrees with me that it's a living, breathing thing. And contractual relationships change over time. Employment changes over time. So I don't like that we set something in stone at the beginning of a relationship, which then might change in substance, but not in form. And we're stuck with this form, this document that says you're a casual, but really in reality you're something else. And look, I know that the law has tried very hard to equalise that, but I would have preferred a substance argument over the form argument personally, because I am a contract lawyer, but we're not working with commercial relationships. We have parties who are not sophisticated. We have very little bargaining power between the parties and how relationship is formed. So why not create more bargaining power throughout the relationship? Why not see how it all goes and see what it turns into as a relationship, as opposed to saying at the very beginning, you're a casual, therefore you're a casual. No matter my and I know he watches, so my stepdad Dean, hello Dean, he was an employee for, I think it was 10, 15 years as a casual, doing the same job every day, same hours, every day. And how is that not permanent employment?
It probably was. I mean,
so just without delving into that, so now we've got this question of contractor employee, and there's been criteria that the courts have put down about this, and we explored this very recently actually in our own work. The substance of the relationship. Is there an ABN? Do you have control over your work? Can you farm this work off to somebody else? Are you a true contractor where you can subcontract the work that you've got to somebody else? Is it your skill and expertise? Are you bringing your own computer? Or you bringing your own tools of the trade, for instance? And there was a lot of criteria involved in this. And I believe that there are a fair amount of contractual relationships out there that just really aren't.
Yeah. So
in form it says you're a contractor, but then it doesn't have all the criteria, like for instance, a person may not have an ABN. And in this case, that was the case. They don't even have an ABN.
Yes, they can't.
They're not remitting GST. They're not doing all the things that you expect a contractor to be doing. And yet this decision came down and determined that they were a contractor.
Well, I think it's going to be 2022's big talking point in employment, especially considering we've got a federal election coming on, and it's becoming more and more of a problem. I think it's getting more and more in the crosshairs of both the courts as well as the parliaments. But I think it raises two kind of points which the employment law area needs to really address, and we need to determine one way or another, which is, are we, is an employment relationship, whether that be contractor versus employee or casual or etc., but is the relationship of the parties set in stone as at the point when they agree, or are we happy to have an evolving system? And do we really want contractors? Is kind of also a separate issue to that. And is the contracting system, or the way it's allowed at the moment, really achieving the goals which we set out for? Because I certainly see there being a area where contractors make sense and it's mutually beneficial, because there are benefits to being a contractor. I think they often get overlooked, which is you still actually have the ability to work elsewhere. You have the ability to advertise and grow your own goodwill, if you want to call it, your own brand, which you can't. Neither of these you can really do as an employee. You also have greater control over the work that you're doing and the way it's done. There are a lot of benefits to that. The problem is where you have a situation where that person isn't getting those benefits and they're only getting the detriments. They're not getting all the entitlements that they should be getting. Then it's really a lose-lose situation for them, and it's really not achieving the outcomes that I think everyone is looking for when it comes to, because you're essentially allowing a backdoor way of making sure people don't get paid entitlements.
But is that the crux of it, though? Are we talking about avoiding employment relationship? Because this is the concept behind the ATOs. Kind of, because if you jump onto the ATO, there is a questionnaire essentially that helps people determine whether they are whether the relationship is a contractual one or an employee one, for the purposes of the ATO. And from the ATO's perspective, we're talking about remitting tax,
Mm.
essentially, picking up GST, superannuation. So there's a bunch of things that the ATO are interested in, because it's essentially an income generation for the state and for the federal government, which is nothing wrong with that. I'm not dissing tax. So is the contractual relationship designed to avoid all the employment stuff, which is sick pay, holiday pay, all the kind of relationship matters that you don't want to have to get into, unfair dismissals, general protection largely, is you get contracted out. Stuff like that. Is it for the avoidance of the employment relationship? Because I think when we think about contractors from an employment perspective, it's about whether this person should be an employee or not. We use it in a negative sense instead of a positive sense. Not should they be a contractor, but should the structure really be an employment structure, and why isn't it? I don't like it. I don't like it in the sense that we've got companies out there who hire contractors for the purposes of avoiding minimum wage, for avoiding entitlements. And what it's doing is it's creating a workforce that is below the poverty line.
Yeah.
And I really don't like that. I really don't like that. And what is a little bit of a scarier fad, I don't know if it's a fad or the way things are moving towards, is in order to get around all this, are they an independent contractor, should they be an employee situation, the workaround is to form a company and have that employee form a company and be essentially an employer of their own company, and you're basically having a contractual relationship with two sophisticated entities. And there is no employment relationship then.
Yeah, and from all intents and purposes, it might look like there is that bargaining power, but there really isn't.
No, it will say it in the interview. Are you prepared to form a company to get this job? And I don't like that. For a start, I don't like it because I think that's not what companies are meant to be formed for. Secondly, I'm pretty sure that the people who are taking low-paid jobs, delivery drivers, cleaners, things like that, don't have the sophistication to maintain a company structure. And it's expensive to form a company. I know people say it's really cheap, but actually it's a lot more expensive than forming an independent contractor and having an ABN. And it's a lot more expensive than being an employee and just turning up to work every day and getting paid.
I also think it's a slightly concerning that it's also quite a sectored issue. And we're always thinking about ensuring kind of a level playing field in society, and I don't necessarily think this is helping, because we're not seeing, I'm going to put a blanket statements around there, and this might not be, it's quite generalized, but it's not happening to accountants, young accountants. It's not happening to young lawyers. It's not happening to skilled workers. It's really happening in the unskilled sectors of the workforce, which is only further causing detriment to that sector and allowing essentially mismanagement of workers, and it's disproportionately treating the workforce in that way. If we think about whether the nature of the relationship should be set in essentially in writing at the very time they start the relationship, versus this idea of a ongoing, changing, evolving type relationship. I like the latter because I think it achieves more of the general outcomes that you're looking for in the employment area. However, I do have some sympathy for potentially more less sophisticated employers Because what we would essentially be asking is for them to have a very clear understanding of when employment relationships, or in this case, it could be contractual relationships, change into the area of employment, and essentially be able to get on the front foot and
Yeah.
avoid it. And
Or,
one of the
or at
problems I
some
can see,
yeah, or at some point have a light bulb moment. Oh, it's changed. Now let's deal with that.
and one of
There
the,
is that light
yeah,
bulb.
it's pretty tough, and unfortunately for a lot of it, it happens after employment, and a retrospective look at what had happened. And for a lot of unsophisticated, potentially very small enterprises, it could be quite a large claim for money,
Mm.
um, and they might just not be able to afford it. And it's not because of any sort of misfeasance or willful kind of trying to escape entitlements or anything, but just ignorance. And
Yeah,
I'm always very careful about taking, for our regimes to really hone down on
just a
ignorance,
mistake. I actually,
mistakes, accidents.
if we use this as a segue into the detriments for employers when they do make a mistake, I actually think it's unfair. Why can't employers make a mistake, rectify it, but not be penalised for it?
So you're thinking more of the way the ATO operates.
Yeah, the ATO will essentially understand that there is a problem that got out of hand. They even understand when a problem gets out of hand and you just make some bad decisions about how to fix it. Like knee-jerk reactions into that sort of thing. What they don't like, of course, is the serial offender or the blatant guy who's just gone out of their way to never pay super and and just go bugger it.
Who's Phoenix the company for 4 or 5 times?
Yeah, exactly. But I really don't like how there's this trend to want to punish an employer who has just literally made a mistake. Like an easy one would be you're paying under one award when you should pay under the other, and it's 2 cents more an hour or something. And technically that's an underpayment. It's a penalty according to the Act, and there are some serious ramifications of that to the hundreds of thousands of dollars. And on your worst day, you can have someone chase you for those penalties.
Yeah.
And I just don't.
It's this idea of having a hammer and ants is rather than kind of just keeping a very open and light touch to enforcement. It's I've got a hammer and I want to concentrate on one ant and then hope the rest.
And if you have a hammer, everything's a nail as well. I know that we've recently, when I say we, I mean we have had recent changes to the legislation to make underpayments criminal actions and things like that. And I'm not necessarily against that, but I think we should be using more discretion and understanding as to why those underpayments have taken place, not just say throw this person in jail or let's give them a massive penalty that will send them out of business and make them bankrupt. And the personal penalties as well. So not only are we making their business bankrupt, we're making them personally bankrupt. So there is no hope for that person to recover probably ever, really, depending on the age of that person and the like they might lose a house. They will almost certainly have damaged relationships inside their family if this is what happens. I wonder where the measurement is on this. So just as a segue into it, because you and I, we do work with individuals who have had, the Ombudsman, for instance, turn their lens on them. And, we're not the judge of whether it's right or wrong, because that's ultimately a decision for the court.
That's for a judge, yeah.
And we're not the decision makers as to what penalties should be, applied. But should there be a them and us when it comes to the Ombudsman? Is the Ombudsman designed to apply as much pressure as it absolutely possibly can in order to be doing their job properly? Or should there be a different approach like the ATO have, which they don't see their role as the executioner type thing. They see their role as getting people back on to the right track, and is really making people bankrupt doing that.
No, probably not. And, if we think about a wider society and wider public policy, companies going out of business is bad for a lot of people. It doesn't take much. If you look around at some of the construction companies that have gone under recently, a lot of people miss out on this. One, the employees themselves. Not only are they out of work, they probably are going to be out of money themselves. All the creditors involved, and the word creditor gets thrown around a lot, and sometimes has this thing that's it's a bank, or it's a insurance company, or it's ATO. But often
to lose that money.
Often a lot of the creditors are also mum and dad companies who did work and didn't get the money up front for whatever reason, and now they're in trouble financially, and they might have personal assets involved in their companies, and so by no fault of their own, now, because someone that they did business with is getting in trouble for something they did, now this particular person, is worried that their house might get taken by the bank because of the potential for their company to go under and for a guarantee to be attached to that. There's a lot of wide-ranging effects on when a company goes under, which isn't really in anyone's best interest.
Yeah.
But then again, on the other hand, you also got to think, if you don't take significant penalties against people, if you don't take action, then are you also creating a situation where you are also kind of rewarding
you're a toothless
poor
tiger.
behavior?
You've got this kind of ability, but you never.
And people see it as a cost on the balance sheet, and that's going to be on the profit and loss.
This is what was going on with the ACCC recently, wasn't it? They weren't actually prosecuting anyone or anything, and it just became this farcical situation where you could be doing loads of bad things, and the ACCC was just never doing anything about it. Look, I think the happy medium is a very difficult balance. I'm not suggesting that these government organisations are getting it wrong on purpose. They're I don't think that, but I think I would like to see I'd like to see more transparency maybe in how a decision is made, and why the decision is made for one person and not the other. Because the other thing we see with the Ombudsman over and over and over again is the choices between who they decide to prosecute and who they don't decide to prosecute. How is that made? And we have employees that come to us and say, well, I've called the Ombudsman and they say that it's not worth them progressing. But then we have other matters where where it's kind of the same situation and it is worth progressing. So,
and it's because of generally it's because of the industry that they happen to fall in. And it's not to say that the actions are any better or worse of the parties involved, but they're not really in the focus area.
I'd be really interested in the transparency about how that decision is made and who is making that decision. Look, I am certainly not suggesting that people out there should be underpaid. And employers should be getting away with it. I am a true believer, if you cannot afford to pay your employees, you shouldn't be in operation.
Yeah. If you can't afford to pay them, you can't afford to have the employee.
But I'm not talking about underpaying consistently on purpose. I'm talking about being, and a really interesting one is all those awards that exclude all the other awards that you don't know about. Like you could easily have a law firm out there that's got an admin assistant who pays under the clerks awards, where in fact they don't realise that they should be paying under the legal services awards.
Especially when some awards get created all the time. In fact, I suspect this year we'll get a new award, and it'll be about gig economy things. And sure, the Uber Eats and the ones that are directly involved.
We're all watching it.
They're all going to know the second that award gets created. But you can see a similar situation. Maybe not so much for that one because it's going to be quite specific. But
the Peace Award has just. I love this one. This is for anybody out there who's ever, and I've segued out of something again, anybody out there who's ever done fruit picking, vegetable picking, and anywhere in the world knows how hard the work is, how thankless, and if you're not good at it, how little money you actually earn. And now we've got this new award that has a minimum wage for piece workers, whether they pick up 10 pieces of fruit or 500. Now, there's this concept, of course, that if you pay them, and this is the argument that was presented, and hand on my heart, people out there, I was never very good at fruit picking. I would be like, at one point I did plums, and
plums are trees.
They're a tree thing. So you're up these tiny little ladders. Yeah, I was doing. I've done lots of different fruits, but the plum one comes to mind because I was so bad at it. So one of the problems with plum picking is plum trees have little twiglets everywhere, and you get all these tiny scratches all up and down your arm, and it's actually really horrible. So I would pick, I don't know, 10 buckets a day, whereas there'll be people out there who are picking 100. They were just so much better at it than me, and they were making money, whereas I was barely paying for my hostel and food. And
you're thinking about the incentives that come with.
Yeah, so I'm going to benefit, obviously, from a minimum wage. I really am. But this poor chap is doing 10 times more than me. Well, there's a bonus system for that.
Yeah, I mean, my take on it is I actually don't see anything different about picking fruit than any other real thing about work, right? Yes, you need to incentivize people to do better, but you also have the ability to govern performance. That's not going anywhere, and everyone has that ability as an employer to essentially make sure people are doing. If you need someone to pick 50 baskets and they're not, then there are ways and means of dealing with that.
You just fired me. No, Melanie, you're not coming back tomorrow. You're too useless.
Yep. And if you need to, if you need to incentivize even greater performance above what the normal requirement might be, bonus systems are perfectly fine. There's nothing wrong with them. And I mean, it also kind of begs the question, if we allow that type of regime, which is essentially a commission only work, why not do that for everything? Why not just, maybe lawyers are the same, maybe you don't get paid anything and you just get a section of the amount of thing you bill. I mean, why not? I mean, if it's good enough for the fruit pickers, why is it not good enough for everyone else? I mean,
those lawyers would starve to death. I can tell you that right now.
I think there'd be an awful lot of lawyers getting up to some mischief and basically running off with clients and all sorts. Imagine trying to keep a hold of the work.
Imagine the overblown work, and like it's interesting, isn't it, when we use a fruit picking scenario, because you can count the number of buckets, but you would have to go back and cost assess that person's work every time, because they might be sending superfluous emails out. They might be doing extra research they don't have to do in order to buff it up to make sure that they're getting and this is a very interesting question, because of course we've got 3 duties, and we've talked about these 3 duties before. Duty to the court, duty to the profession, duty to the client. I don't see a duty to yourself there.
No, there isn't.
So it's kind of, and
I mean, unless you take a broad view of, if I do right by me, then I'll be in the great mindset to do right by everyone else.
Yes, but lawyers from time to time, and we've had this, are in a position where we have to essentially screw our own careers for the benefit of our client.
Yep.
We have to do something that we know is not bad, but just not good for our own careers because of our duty to the court.
I mean, I don't know if we've spoken about specifically on this particular one, but kind of one final story, I think, for our listeners, is this particular case, and I'm remembering back to my uni days here, but it certainly comes to mind. I'm sure every lawyer's been taught this, but I might get some of the facts slightly wrong. But the general thing's
a lot of
pretty
people writing and going, you got that wrong, Chris.
it's a long time ago, but I'm remembering off the top of my mind. It's about two lawyers, criminal lawyers, who had their client say to them that they had murdered someone and that they knew where the body was. And the client said to them, "I'll take you to where the body is buried and show you." Now, they did, and potentially that may have been a mistake. But putting that aside, but anyway, they went. And the kind of matter proceeded. The guy got convicted of murder, and there was some dispute as to whether he basically didn't tell anyone where the body was buried, despite these lawyers knowing. Now, the lawyers knew that they had a duty of confidentiality, which is quite strict, that they were owing to their client. Because the client had specifically said that he's not going to tell people, but they knew. And so they didn't mention anything. And it later came out that after finding the body, that these particular lawyers knew the whole time. And they were berated by the public. Really, really media storm. It was seen as an absolute outrage that they had just derogated their duty as almost an ethical thing, and almost assisted in the crimes themselves, which is dubious. But they were, the modern day witch hunt against these particular lawyers involved. I believe one of them was a partner or principal of the firm for which had carriage, and the firm went under. I think he even had like some family problems that came after financial distress. Really, for all intents and purposes, ruined his career. All right. But from the public standpoint, you think they did the wrong thing. This was immoral, unethical. But from a lawyer's standpoint, they are pretty much champions of upholding your duties, because on a personal level, there was never going to help them on a for their personal careers. In fact, ended up really hurting them. But their wavering commitment to their duties cannot be understated, I think, and really should have been congratulated. And it's really disappointing that the wider public didn't understand the importance of client confidentiality.
Privilege, all clients want it, but they don't want it for the other side.
They get really frustrated when they knew about it at the time.
Yeah, when they know the other side has some information and they don't have it. It is a very interesting dynamic. Everybody wants it, but nobody wants the other side to have it.
I think a lot of this comes from the fact that people never think that they'll be in a situation where they need their lawyer. And it might not, this was a murder situation and whatever. This is an extreme. But, the day will probably come where you need a lawyer, and you're going to want the confidence that they're not going to basically act on their own personal interests and disclose things and to your detriment. Because what ends up happening is no one's going to trust their lawyers, no one's going to say anything. So case is going to be run where argument's going to be put forward, and that's just simply not the case. We're going to get wrong decisions, and we might not even know that they're wrong because the only people involved just didn't tell anyone.
Yeah, just not look, the amount of times that I've been running a case and running a matter and my client hasn't told me everything, and eventually it comes out, and I could have made a different play, and I could have got a different outcome that was better than the outcome that ended up happening, because if I'd known at the beginning, I would have built a different strategy.
Yeah, and they just didn't have the trust to disclose it to their lawyer.
I cannot stress for those who are watching who are not lawyers enough how important it is to be brutally honest with your lawyer, So they
Tell
have
them everything.
all the information. We're not here to judge you. We don't actually care whether you are a good or bad person. We don't care whether you hated that other person or didn't hate that other. We don't make these value judgments on the situation. What we're trying to build is a strategy to get the best outcome for them. And if we don't have all the information, there is no way we can build the best strategy possible. And it happens, I don't know, half a dozen times a year where I could have got a better outcome for my client if I had known at the beginning the thing that was happening, all the information attached to it. But look, there's no way we can explain to our clients that it's actually okay, because our clients want us to like them.
Yeah.
And they think if they admit something that they did that wasn't so great, that we're not going to like them. And my value judgments don't sit like that. I have my own personal moral values, but my work ones don't align necessarily with my personal values.
Well, I certainly find that, and this is certainly a comfort to a lot of clients out there, and for people who are seeing their lawyers, we don't even really turn our mind to it. I certainly don't. So I'm not even engaging in an assessment of like or dislike. It's just you don't even turn your mind. It's not something that you do.
No.
And I think most lawyers are the same. So even the ones who are, haven't done anything wrong, maybe they've been, let's call them the blameless victim. I don't even turn my mind to whether I like them, because it's just not relevant. It's actually not relevant.
Look, I don't think necessarily TV shows help. Advertisements don't help. I'm on your side. We're working, we're always on your side. If you engage us, we are on your side. There's no other side to this. If
Lawyers love to win, so we're on this side.
If you engage us, we're on your side. This is it. We are acting in your best interest the moment you engage us. So I think having this kind of concept where there are lawyers that might be on your side and lawyers that might not be on your side, it's a farcical situation. The moment you engage a solicitor, they're acting in your best interest.
Yep.
So that means all lawyers are on your side, and no lawyers are, depending on whether you engage. And we've got the TV shows that show that that we have these conversations behind the scenes that talk about whether we want to screw this guy because we don't like them as a client. That's not happening in real life.
No.
You're a client of ours. Our duty is to you. That's what we do. It's as simple as that.
I think the TV shows definitely overplay what actually goes on behind closed doors. Basically nothing.
Overanalyze our interest in these people's personal lives.
No, which lawyer has the time? Who has the time? We got billables to make.
Yeah. That's true. That's not to say we're not acting in the best interest. Absolute, and doing the best we can for that client. But we're not intricately thinking about them all the time. And if we were, we would be charging them. So why would we be doing that anyway? Yeah. Crazy. Well, I think on that note, we will close off the Lawcast for today. We've kind of segued from a crazy Galah case
to lawyers looking at a dead body and not disclosing it,
and our duties to our clients. Yes. Well, thank you, Chris, again for coming on board and having a chat today. We'll be back in 2 weeks' time. For now, thank you for watching the Lawcast, and we'll catch you all again.
See ya.
Yes.